way too hot outside. Holy cow. Wait, what does it mean? Chat is... Oopsie. Oh, I'm in the wrong thing. Oops. So dumb. Oh, man. Okay. Oh, yep. Glitch me out. No problem. Refresh. Oh. I'll be right back with the hair tie, guys. Oh my gosh. It is so hot. Sorry, guys. Oh. Sorry to be late. We are going to be starting this live stream off. We're going to catch up pretty quickly. I'll get it to 1.5 speed. It shouldn't be too bad at all, and we'll catch right up. I had to do a lot of yard work. We had to go all the way in to get my wife's check because for some reason, over a year now, they can't figure out how to do direct deposit. They are the most worthless company I think my wife has ever worked for. It's unbelievable. I'll be right back, guys. I'm just going to grab a hair. I thought I had a hair tie here. Okay. Oh, there we go. Man, it is so hot outside. So anyway, I ended up having to blow up my kids' pool too. Now they got a nice brand new blow-up pool from Atwood's. Good old-fashioned fun right there. Oh. So now they can be out back screaming, hanging out with the wife while she's getting a tan. And, jeez, it is so unbelievably hot out. Yeah, my wife's job, I don't know what it is about it. They're a corporation. They're going super bankrupt right now. They're getting sued like crazy. And for some reason, over a year, they have not been able to figure out how to get direct deposit going. It's unbelievable. It's unbelievable. So we had to go all the way to them again because we thought they had it fixed this time, and they don't. They didn't even notify us that they didn't get it fixed. We had it all good, and they're like, yep, everything looks good to us. And I was like, finally. Good. And they just decided not to tell us. It's unbelievable. Absolutely unbelievable. But you know what? I can't wait to get her out of there. I cannot wait to get her out of that job. It sucks. Anyway, guys, how's everyone doing? Good to see you all. Let's see who all's in here. We have Dent-C. We have Libslayer. Heck yeah, good name. Avenge. Angie. Grits. Love when Grits is here. Steampunked. Brand new troll from yesterday. Thank you so much for being here. I'm a little big, aren't I? Okay, there we go. I'll try not to be dumb for too long. Wearing a big oversized shirt because it's comfy. And I thought it would be this turtleneck part, though. This part, it gets way too hot. Everywhere else, it's great. This is a great American Eagle shirt for summertime. Too hot, though, right around the neck. Melissa, we got Sherry. We have, who else have I not said? Who have I not said? Not a lot. Sabs, of course. Of course, we have Sabs. Thank you for being here. Mister, we got Mister, of course. You know, I mean, most of you guys. Aileen Granger, wow. Oh, yeah, and then you... All right, you changed it to a nice, crazier Q. Where did you get that Q from? You get it together. I will dox you. I will dox you straight up there. Yeah. Aileen, that is your real name. Hey, Renee Fairy Dust Bunnies. Thank you so much for joining as a troll. I really appreciate that. We have Lois Lane. Nah, Lois. I love that. Lois. I wish I could do his voice better. Hey, Peter. I can do that one a lot better. Cusco. Poison for Cusco. That poison. You know, that whole line. That's a better line. That's a better line suited for my voice too. D. Hampton. We have Madeline. Margaret. Margaret Munson. I don't know where the name ends and begins for your first and last name. Sorry. From New Zealand though. Heck yeah. Heck yeah. Catastrophe. Yeah, you. Yeah, you Aileen. It's not even your real name. Why are you going by Aileen Granger? What's going on with that? That's some, like, book character? Aileen. Yeah. Gotcha. Hey, Victoria Greenfield. Thank you so much for joining as a troll. Ask my wife. Okay, so it is from you guys' dumb book. Gotcha. Cass and Victoria. Hey, you love Kronk? Heck yeah. Kronk is the best. Oh, man, my kids are obsessed with Kuzco. Such a great movie. We've been watching the crap out of that. It's one of my favorites. Can you believe that movie is 26 years old? I think it came out in 2000, right? Is it 2000? It is 2000, yeah. Came out in the year 2000. That film is 26 years old. That film is old enough to have kids. Putting that out there. That's crazy, right? Susie Q. Good to see you. Mama Owlbear. Hey, good to see you there. Alrighty, I think we got everybody. But yeah. Hey, Aileen, is your husband watching too? Is this a family gathering? Let's see. My husband is from Oklahoma. Beaver in the Panhandle. That's a cool place. That's a really cool place. I want to go. Oh, I really want to take a vacation at the Gloss Mountain, or what's right there? It's right there at the very corner of the Panhandle. What is it called? It's let me pull it up. Out of the way here. Okay. I want to see any of this. There we go. What is it? It's like right in the very corner of, where's it at? Near Boise City, I think. Is it Sturgis? There's some crazy monument out there or something. Oh yeah, I see where Beaver is right here. Okay. Right below Forgan. Above Elmwood there. It's Black Mesa. That's right. So Black Mesa is up here too. Right by the Gloss Mountain. Oh man, would I ever love to go out there. Where is let's see, Black Mesa. Yeah, it's at the very, very, very corner. I'll pull it up here. So Black Mesa, this is, sure there's no crazy information that'll get leaked. Because you never know with Google. It's right here at the very, as you could see, zoom out, and then you could see right here at the very tip. You got Black Mesa out here, which it's just awesome. Awesome. Like we have got, I have got to take the family here. All these beautiful areas here. Someone's walking their dog. Obviously, probably a tornado somewhere over there. Let's see. You can't take a picture in Oklahoma. Yeah, Black Mesa hydroelectric power. I think this was a concept. I don't think they finished that, did they? Why do they make this? This is obviously a render. Interesting. And then we have what's it called? We have Gloss Mountain State Park over here in Fairview, which is just, it's a decent way. It's close to the Panhandle, but it's not quite there. The Gloss Mountain here. Look at that. Oh, I don't want to see the video. So Gloss Mountain State Park. Got all this. There's a lizard. Probably going to catch him. Yeah. Beautiful area. This is not what my area of Oklahoma looks like at all. I could show you what my area of Oklahoma pretty much looks like. This is pretty much like the... Yeah, we see place. This is pretty much what my area of Oklahoma looks like. Not so rocky. It's more forest than this, but I don't want to show you guys where I'm at, obviously, because that'd be a very silly thing to do. That's exactly how the Candace fans will find me. But, is there any part of the... Here we go. It's like this, pretty much. Very thick woods. Yeah, this is a great depiction. If y'all know the history of Robbers Cave at all, this is where... what's his name? The most famous cowboy criminal ever. He hid out here. He hid for like 3 or 4 years in Robbers Cave and eluded police and all that. What was his name? Who hid in Robbers cave. What was his name? It was Jesse James. Jesse James, but a lot of people obviously did. Bellstar, the Dalton gang, the Younger gang, Rufus Buck gang. But Jesse James is certainly the most famous person to hide out. There's little documentation proving the outlaws lived in the caves full time. The rugged remote terrain was then Indian territory provided by Natural Legendary Sanctuary. But I think they admitted it or something. Like when they got caught, they were like, where are we at? It was like Robber's Cave. So, but yeah, they called it Robber's Cave because that's where a lot of people hid out at. Some pretty cool lore, isn't it? Let's see. Renee, oh, you sent a gift membership and Sherry Rose got it. Heck yeah. I guess participants in the chat get to reap the benefits. Because it's nobody that, it's everybody that I see in chat that normally gets it. That would make sense. How much do caves rent for these days? Well, if you're sneaky about it, you could just stay there. Jesse James didn't pay no fee, so why should we? That's a rhyme that's going on a t-shirt. There we go. I'll just have stupid t-shirts with stupid slogans on them. All right, let's get going.
Versus Tyler James Robinson. Counsel, please enter your appearances.
This mirror is this quiet now.
Chad Brunander, Ryan McBride, Lauren Hunt.
Yep, volume's all the way up.
County Attorney Jeff Bray and Chris Ballard are also present.
Wish they could balance their audio.
Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record,
Watch the volume just crank up. I bet that's what
presence of victim
happens.
representative, Ms. Erica Kirk. Good afternoon.
Hey,
first,
thank you,
with respect
Joni.
to courtroom protocol to maintain security.
Is it Joni
and decorum,
Weiss or Vice?
any individual who exits the courtroom during the proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections.
I mean, she's definitely
electronic
pro-Russia.
devices and care to
There's
avoid
no doubt
inadvertent
about
capture
that.
of privileged or private discussions by recording equipment or by those present in the courtroom. And as you note, the microphones on your tables are turned off, so please
That's a
come
good
to the
question.
lectern
Who really did
making
get Jesse James?
when you're addressing the court. Second, the court will address the camera and still photographer.
He's so stupid.
Camera operator and still photographer. And if you both could come forward,
Those are
please,
good.
to the
Right
lectern.
about there. That way we can always see the witness. That is an incredibly bald man.
All right, could you both state
Counsel
your
of the
names?
Balds, may
John Wilson,
convene.
KSL Television.
Tess Crowley, Deseret News.
Good afternoon. Could you state your roles for today's hearing?
Video recording and streaming of
I
the
don't
proceedings.
care.
And the pool
We can
still
skip this.
photographer.
Order and complying with cooperate. Dignable witnesses, courtroom. The court also expects that every person in attendance expect distracting, make audio works, include address.
Yeah, we get it. Decorum, all that good stuff.
Your
I'm
duties
not too far
to
behind, Boggs.
And
I'll
with
catch
that,
up.
I wish to inquire of a brief overview on what is.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the
got
courthouse
louder.
and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation
Edie.
of the evidence
How
on the
you
part of the
doing?
state.
Thank you, Mr. Grunander. For defense.
Good to see you.
Good afternoon,
Rita,
Your
you
Honor.
went to Tulsa
Michael
back
Bird
in
from Mr. Robinson.
1999?
Judge, we have two remaining
That was the
witnesses.
peak time to go. Did you see
Miss
the
Oliver
Eastland
from
Mall
the,
before it closed down?
ATF and Miss Carner, also from the ATF.
Oh, now we're getting ATF. Okay. Heck
Right,
yeah.
and to both parties, thank you. I appreciate
Grits,
that. To
this
both
isn't,
parties anticipate
none of
any
this is a
issues,
surprise to you, though, huh?
concluding their case. Obviously, there's variables, cross-examination.
I kinda
and-
like being
and the
surprised
fog of
with
war
what
that
evidence
happens
we're
in
getting.
court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.
Not from the state, Judge.
Wait, Andrew Wilson puts toupees on the bald guys? Really? That's really funny.
That the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we
Well,
did
of
that
course
was we
you don't.
provided a transcript.
You're gonna waste their time
and then a
today, aren't
redacted
you?
version of the transcript of the entire video recorded interview.
Boo.
It may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court
So if you
time
could just get
for the
reading
court
on
to
that.
look at the proposed redactions
Every one of them is going to be garbage,
may
too.
be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. And so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge.
Appreciate the heads up, but I wish you wouldn't have done it.
No, the state has received the proposed redactions, and we are prepared to address them when that time
Jenny.
comes. However, we do intend on presenting testimony through
Arter.
Mr. Davis, through Agent Davis, and when we get to that point,
RDR.
when it's ripe for discussion,
Hey,
we
Lisa.
can address the matter with the court. That would be our
Hey,
preference.
Wimshaw.
All right, well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you.
Duty.
All right, does
I
either
have a duty.
party require
All right,
the
here
benefit
we
of the
go.
record?
Okay, are we getting this started now?
And at the second half, must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In
All
our,
right, they're gonna
the
argue
court
this.
holds two roles, magistrate, and I know your court can consider that. And that court has held the itself admissible. We're acting in its fact-finding role.
I can make this guy dance, I bet.
Admissible evidence,
Wait.
prior bad acts, and what it considers potentially inadmissible evidence. Is the state has labeled exhibits that kind of admissibility take the jury pool on the class taint.
Briefly, be technologically savvy.
All right. Are they arguing this
We'll
now?
continue to raise concern.
Okay.
Right,
Let's
to
just
both
get the
parties,
witness up
the
first.
standing request remains, when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a
finally. That was a
screenshot
problem yesterday
that angle
that
creates
I was
an
having.
interesting angle that kind of distorts it. So in the interest of
Oh, yeah,
we're gonna be
Jenny, I'll play a little
transparent,
bit
it
of
should be
guitar on the,
viewable
lunch
transparent.
breaks.
So we'll adjust that screen briefly, but please address those 3 issues. And I understand
Hey,
one
real
side or
George
the other.
Farmer.
Well, we agree or we
I
don't agree.
believe you're the
period,
real one.
But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that
Get her outta
compliance
here.
is adhered to.
Don't give her
With
a
that,
coat.
turning to the state, you
Get
may
her
call your
out.
next witness.
Just kick her on out of here. She didn't
Yes,
even
I
do
want
anything wrong.
the press to be able to see it too, but when it's there's a bit of distortion when it's at that
He's
particular
a pretty
angle.
through
So,
judge. He's a pretty
while the
patient
parties are
judge.
getting
I would
moving
be a
forward,
lot
go
less
ahead and
patient
adjust
than
it,
him,
and
that's
let's
for
put a
sure.
sample image of.
I'm
going
going
to
to accidentally call you by your real
name.
name. I'm just letting you know that.
I don't know that it is projecting yet. I don't know if we can take a break to make sure that's working.
Hey, Mochi.
Is it not projecting
Did I
on the
already say hey,
monitors?
Mochi? Probably.
Okay.
Probably
Technology
did,
is
because you're right above
challenging us
the
again.
real George Farmer.
Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming? That. Not
Boy, they do got a lot of technical difficulties this morning.
right. I appreciate it's displaying. All right, and needed for that. Then we can do. Bring in that.
Testimony you shall give in the case now of God.
Okay, they're swearing
for
in.
that,
State your name and spell
Oh,
picking
there
up
we
your
go.
voice and have a good record.
Wait, who's this
To
guy?
ensure that it
Doesn't
is
pop up.
picking up. Have to adjust that microphone. Pull it down in the region. If you wouldn't mind having a
There
seat
he
to your
is.
left is a water bottle, and after you're seated, you'll have to adjust that microphone. Pull it down and then pull it toward you to ensure that it is picking up your voice and have a good record.
Yeah, I mean, put the microphone in front of your mouth. Kind of moron
All
doesn't know that.
Ms. Hunt, your witness.
I see a
State
lot
your
of
name and
people
spell
that.
your last for the record.
Yeah, it's Brian Davis, D-A-V-I-S.
What is your occupation?
And I'm just like, what are you
I'm an agent
doing?
with the Utah State Bureau of
Just
Investigation.
talking to this. Don't leave it alone.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement.
He's with the OSBI? Hold on. Did I hear that right?
How long have you been with the SBI?
A total 18.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
Oh, it just said SBI. Okay. I was like, what the heck is Oklahoma getting involved for? Eric Goss for $20 says, hey, Artie, love your work. Just got a video in my feed from Candace supporter Heavy Duty Country. I don't know who that is. This trial is not going to convince her most loyal follower. Can link if you want. Sure. Yeah, you can link it. Man, I appreciate that. I don't know who that is. I've never seen him before. I'm just genuinely like not surprised at all that their fans are coping with this.
A total 18 years.
Thank you, man. I
I want
appreciate
to briefly
that.
go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
Well, yeah,
How long have you
to
been a
be.
law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with
Okay.
the Utah Transit Authority Police.
We've
That's
heard
not too
talk
surprising,
from other
though.
officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Boy,
Is
99 is
that a
coming
type
up
of
a lot
certification
today.
that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah,
Wait,
local,
this
state,
guy's an
county,
arrogant
all,
bud?
go through to become a
What's wrong with
certified
him?
peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a
Wait,
bit
hold
about
on. Real George Farmer just said, I've been doing my own investigation into all-male nightclubs in Spain. Has Milo been around?
your training
Yeah,
experience
that's awesome.
within law enforcement. What roles have you had at SBI?
I began as a alcohol enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on
So
several
I'll be
different
honest, I don't know if
OICI
she's
protocol
offense or
teams,
defense.
officer
We'll find
incident
out
teams
what
around the state of
line of
Utah and within
questioning
SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I've worked anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI Public Corruptions Task Force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
We're behind
You mentioned
our-
you've been a part of
we're only
homicide
15.
investigations.
Okay.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state.
Okay. You're probably right there, Aileen, seeing that you are very involved with this kind of stuff. Probably the state it's probably the prosecution.
State of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
It makes
Have you
sense
received
because
training
they have to
specific to
make the
homicide
accusations
investigations?
first.
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a Feral certified. It's a 3D Feral scan of crime scenes.
What's a Pharaoh
He's
scan?
a trainer.
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm been certified as a forensic interview in the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen
Hey,
that
you're
case
good, Grits.
if applicable
This
to
testimony's
the
good.
appropriate
Okay,
county attorney or
glad to hear
DA.
that.
You mentioned that you are a co-case agent or were with Agent
Wait, did I see the investigator who found Twigs in Texas? What happened? Is he like, did something like happen to him or something? I'll look it up.
Is it typical to have two case agents on a case?
It can be especially on a large case. Yes,
Has this particular case been large?
yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are
I don't
probably
see anything about it.
several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Warren Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about what we've. So, as a case agent, have you been in court during this preliminary hearing?
Yes,
You've heard prior testimony.
yes.
We've talked a lot about.
Wait, the investigator. So the investigator moved his whole family down there to Texas, where Lance Twigs is. The investigator approached him at like Taco Bell, but Twigs said he couldn't talk. Huh. I mean, it's interesting. I'll look more into that.
The events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant L. Schulz requesting that I travel to St. George.
Who is Sergeant Elschels? What agency is Sergeant Elschels with?
with SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual had.
Eric, for the $5. Thank you for that, man. Wouldn't let me super chat link. Look above normal chat. Okay. Let me see, Eric. Well, actually, I don't have to do that. I can just click on your name. It's a fun little trick. Oh, if the computer will let me. There we go. And channel activity. Let's see. Oh. It will not let me see your link. That's BS. YouTube, I wish it would let me do things. Yeah, I guess it blocks your link. Do you have an X account? You can just send it to me on X.
Was turning himself in, or had turned himself, was going to turn himself in
I
to
appreciate it,
police
man.
in regard to his
If
involvement
you
with
wanna-
the incident, the shooting on UVU campus.
Send me a link here.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of
Travel
September
down
11th.
St. George.
Did anyone else go with you?
Here's my
Yes,
X
so
account.
we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was
I'll just pin it.
Sergeant Elschels,
No, don't go to
was
jail.
Agent Folger
No.
with FBI, Agent
Yeah.
Anderson with FBI, Ryan McBride and myself, and the two pilots
And who is Ryan McBride?
with the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30
Ryan
p.m. at the St. George
Anderson.
Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Subscribe to him.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well,
Thank
with
you,
FBI,
Boggs.
as
I
we
just
were
subscribed to
traveling,
him.
and then along with mainly the
I'll watch
Washington County
your
Sheriff's
stuff.
Department. We also have agents within
I appreciate
SBI
that,
assigned
man.
in southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
Did you mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about
Latest
9 p.m.
video.
that evening.
4:45.
And was he with
Okay.
anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with
Hey, guys.
this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also, at that time, the family friend Mike Mitchell was interviewed by other agents.
So this testimony completely debunks Baron Coleman's lie. Which lie, so I can watch out for it. That way I could just immediately be like, bam, on it. I appreciate that info, Grits.
As well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
I think my favorite part about this today is the fact that she gave herself layers to look like this lady right here behind me. If only she had white hair, she would look exactly like an old-fashioned powdered wig judge. Look at the layers in that. Both of these women have way better hair than me, by the way. You know, some people are just like, oh man, you know, I got good hair and all. Look at this. They got way better hair than I do.
And yourself interviewed Tyler's mother?
Yes.
But this is hilarious.
I just want to make sure the record's clear.
Like a
Who
judge.
interviewed Tyler's father?
I think I might have misspoke. It was Agent Holgreen,
Not in a
Agent
bad
Cox.
way. Not
that met
hilarious
with
in a bad way.
His father.
Yeah.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
Ah.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
Hey, thank you, Betty.
And what date did that happen on?
Would have been September 12th.
There you go.
4 a.m., I believe, of September 12th.
Okay.
All right, I want to show.
So Baron Coleman just gets debunked completely. He was arrested September 12th. There you go. I want to see Baron Coleman have a fit about this. I'll pull it
Just
up.
on your screen, not for
Let's see.
public yet, what's been marked for identification as State's Exhibit 15.
I bet Britta's on it, huh?
Let me know when you're able to see
Nope.
that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, can I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
That may happen a couple more times as we go through exhibits
I
because
understand.
of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
That's correct.
we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Oh, okay, you put it on my pin post?
Let
Awesome,
me
awesome.
just confer with my paralegal.
Why doesn't it notify me?
Oh, that's probably right. The difference.
It has no audio, so we would like to admit and publish it at this time.
All right. State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and maybe
All right, I got it
recorded
saved.
or transmitted electronically. Just
And
No.
Your
To
Honor,
me,
of course,
was
this
kind of
is
acting like
subject to
skin-
all of the objections which have been previously reserved in writing and reiterated over the last couple of days.
All right.
I assume that we don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media.
Why'd
can
their
you do that
volume
screen
dip?
okay? All right. State's Exhibit 15 may be played.
Annoying. Gonna have to play compressor today.
And Agent Davis, who are we
Oh,
seeing
hey,
here?
look at that. Look at this guy. I guarantee you this guy here isn't Tyler Robinson, right? He's also like 6'20".
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's wearing a dark-colored baseball cap with it's like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short-sleeve shirt with no
Candace
graphics.
Owens is gonna
It's,
hate that.
blue jeans and gray and white tennis shoes, I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any I guess, personal property taken from him, clothing, anything like that?
The only
Yeah,
thing was, so
6'20".
prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person, but that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
Well, let's see
And sorry,
Baron
you may have
Coleman
already
and
stated
them
what time.
try to wiggle their
when
way
did
out
he
of
arrive
this.
in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individual's personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And
Fun fact, when it comes down to a court of law, you notice how the trans guy is Lance Twiggs, and he's a he? I just wanted to throw that out there. I figured it was relevant.
who is he in relation to the Robinsons?
So he's a family friend, a close, good family friend.
And what was his involvement here?
So he helped facilitate working
I was
with
talking
Tyler's
about you,
parents,
Madeline, I'm pretty sure.
with the sheriff's department for
When I
Tyler to
said
turn himself
hello.
in.
Or was it a
And
different
I believe you
Madeline?
mentioned
Do
previously
we
that
got
law
two
enforcement
Madelines
conducted
in
an
here?
interview
Well,
with Mr. Mitchell.
hello to you, Madeline Harris.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County
Spanish,
Washington County Sheriff's
Madeline.
Department.
And I know you've already stated, but
I
remind
don't
me
think
who was
that's
present for
what
that interview.
Roger said.
That one was Agent Terry and Agent Smith.
Hi,
What
Rabbits.
agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Durfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Durfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement.
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George court office courthouse there. They met and discussed
Ooh,
briefly.
5 kids, good for
They kind
you.
of talked generally about the
Say
situation.
hi to your husband for me, too.
From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by
Jennifer.
himself. Was there for about an hour, where he
So many New Zealanders.
wrote a statement, filled the
Thank
statement
you.
out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the
If you
information you're
lie,
giving is
you
true and
die.
accurate to the best of your knowledge. That any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Okay, or
Aside from that being written on
like
the
my
form,
version better,
are you
but,
aware if this
you know.
admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
whatever he
Yeah,
says,
Ryan
I guess.
McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down.
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you
Now, you
What's been
Kiwis,
marked
stay away
for
from that dang
identification as States
exploding
Exhibit
island.
14.1. Let me know
I
when you
saw
see
that
on your screen.
documentary.
Okay, we see it.
What is that?
This is the written 1102 statement that was provided by Mr. McMitchell.
Your Honor, may I have a minute with Ms. Hunt? The same purpose.
All right.
And how do you know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So,
And Kimberly, if I can have you slowly scroll down.
Well, you know what irritates me? These brand new computer parts. You know, like I have a 5080. And there's one computer powering all of these freaking monitors. And right now, the newer stuff that is struggling just to do this stream. I don't know what is going on. But it irritates me because these guys are on like a freaking old system with very old hardware. And it's powering all of these monitors from one source. It's so frustrating. I don't know what the heck happened. Just a little thing I want to throw out there.
Sorry, Judge, if I can just have a moment.
You may.
No. Get no moments. Why are they zooming in on him?
I apologize, Your Honor. I misspoke. It's not 14.1. It's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only.
All right.
Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, States Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom
no
gallery
way,
or the-
Grit. So you're telling me he pulled, Baron Coleman pretty much pulled a Project Constitution, like what he did with the Epstein phone call. So Baron ended up pulling 3996-R2 when he should have, in the video is 3996-R1. So is that what you're saying? So he purposely pulled another piece of evidence in order to say that he was arrested, but only at the time he was Mirandized? Yeah, that's crazy. Don't worry, Coleman, it doesn't even matter if he's disbarred or not, because he's never won a single court case. He's never won a court case. It's crazy. Like, he has a win because he got a guy off of 13 out of 14 charges. I still count that as a loss in the end, kind of. Like, it's technically a loss because his guy lost. But it was an uphill battle. He wasn't going to win it no matter what, but that's the closest thing he had to a win. My favorite loss of Baron Coleman's is how he tried to get the guy off of, you know, the guy who spread to the other guy AIDS. And he was like, well, because he didn't do it with a woman, he's not liable. And that's the one where he fought against Pam Bondi back in 2013, and Pam Bondi crushed him. Hilarious. Very, very hilarious. And then he would go on to see Pam Bondi go and become the AG, the Attorney General. Was she the Attorney General? Is that what she was? Yes, she was the Attorney General. That's right. And so he'd go on and watch her do that while he stayed at home and cried in his pillow.
or the cameras.
All right, can I have a copy of
Pretty
it?
good.
What I have is the unredacted version, so I want to review it before I
Yeah, he fought Pam
make a decision.
Bondi in a death battle in court. It was in a Florida court in 2013, and he lost brutally. Brutally. Wasn't even close.
If I may approach.
You may.
He made the worst possible argument, too. That his client was not liable for giving the other guy AIDS. That he wasn't liable because, well, the other guy wasn't a woman. And because Florida law says to have relations, it has to be with a woman, therefore he should just get off charges. The judge was like, no, he spread a disease. Knowingly. Absolutely not. You guys should look that case up. It's very funny. I've covered it on the channel before. On the Baron Coleman video I did. So, pretty good. And that was a special thanks to Paramount Tactical for pointing that out to me. I thought it just great.
13, and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties. Is now
Okay, good.
published.
Thank you,
Do
Judge.
we get to see it?
All right, I want to move on to another topic.
Oh,
You've
never
stated that
mind.
you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Okay.
Do you have knowledge
Oh.
about what
Never
that,
mind. Different
about that
bullet.
bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the
Oh.
auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there,
Okay.
east and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider,
I
there was not a
believe he
line of sight
practices
from there
in
to where the
Florida.
tent was.
Mark White.
where Mr. Kirk
I
was.
could be wrong. I think
Did
he
you learn from
practices
Agent
in-
Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
Oh,
It's a round that had not been fired, so it still had the projectile and it was a fully functional
okay. So he had an AR up there. Okay.
bullet with ammunition with the bullet.
Did you learn if this 223 bullet found on top of the computer science building was a live round?
Yes,
And how do you know that?
it was still intact. Still had the primer had not been it was not the dent had not been fired. It still had the bullet projectile in the end, still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. Are you, you
Oh, wait,
mentioned
am I
him already,
allowed?
are you familiar with an
Sorry.
individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware if Mr. Twiggs' buckle swab was taken at that time?
I don't recall it happening there. I believe it happened later. I'd have to. It did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but.
But ultimately, a buckle swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview with Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so
In other words, they're not going to arrest him right then and there. They're going to let him go home. But if the DA came out and was like, dude, he did all this, I'm sorry, we can't let him get away with that, so go ahead and pick him back up. That's essentially what he's talking about.
for any statements
From what
made
I
during the interview,
understand.
they're given immunity for that,
If
but they're not
the
generally
DA
prohibited
decides
from
to.
being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
Ooh, hopefully we get to see those interviews at the trial.
We've talked about 1102
I'm sure we will.
statements. We talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
That's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did. Yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first. And if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not. I did mention that defense prepared a transcript of this recorded interview. How the state intended to present it and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it. That they had an opportunity to make these objections if they had them at the time when the 1102
Agreed. They missed their objection window. Tough.
issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if they're isolated statements that the court would not ultimately consider. Again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial.
Respect her authority.
State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans 2024 UT App 128. And those cases all stand for the note.
Yeah, he has his Tyler has his phone in the video, so that alone proves Coleman is a liar. Coleman made the big deal that Tyler couldn't have had sent Discord, any Discord messages because he didn't have his phone. Yes, agreed. This is a bad day for Baron Coleman and Candace.
And that essentially judges, and this is a quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy, asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video
Yeah, I
recording
can play Panteras
1102,
Unbroken
that
after
remedy
this.
is disproportionate.
Why not?
If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into evidence states exhibit 16,
Yes.
and as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits, so we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right. And
Really? Are we not going to get to see it?
in regards to this exhibit, is in the, as states exhibit 16, is there any portion of that recorded statement that occurred before the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, so turning to the defense, Mr. Novak.
Thank you. So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry, the court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined
Hey, you're good, Bagger.
to entertain
I don't
until the
know
moment, as
what
the
you
court
mean
has
by
said
cue.
many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript.
Oh, it's only 20 pages that we should have
We have
done a
given the
while
state
ago.
a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 1102 interview.
We should have just got it back
There's
sooner.
no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem, because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits
does have
that
a
this court
tiny
will
little
be
hand, doesn't he?
asked to receive into evidence today, which are text messages and group chat. I'm just going to distinguish between
Put
the two.
away.
And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those
Glad to have you here, Badger.
two
Thank you.
things that I just talked
Name and
about are
face.
going to be presented to the court by the state. There are also portions of this 1102 which are not
Yeah, this
relevant
guy does talk a lot.
and really implicate Mr. Twiggs' privacy rights. And I'm not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially
Oh,
to be broadcast,
get off the whole not relevant. You
implicate
did so much
other
not
privacy
relevant
interests.
garbage
So,
yesterday. Up yours.
I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the
Well,
state
guess
with a
what?
transcript,
Surprise, that's
with
what
a
you
proposed
did.
redacted transcript. And in fact,
What's wrong
today,
with this dude?
we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to
Hey,
look at
Sky
our
Cutie.
proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that
Heck yeah.
if the court did order,
hanging out in the tire shop?
ultimately, that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool
I like how
to
this guy
address
just lets this dude
the
just hang
inadmissible
himself. What's
portions
going
of
on?
the video. Because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it would probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it until we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court
Dude talked
proposed
more than Saul
redactions
Goodman.
to
Oh,
an
yeah,
exhibit
for sure.
in a hearing which hasn't started yet.
Sally
In a hearing in
Al
which
Ghul.
the state hadn't
Good name.
until 20
Good
minutes ago
name.
even proffered it.
Sounds like you're a Batman
so
fan.
I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But
Oh,
the
if
reason why the
Bendis
state
is
is
in
going to
here.
the procedural issue is because the
Just want to give you a little bit of an update. We're probably going to continue playing some more of that Lego Batman here. Maybe this, we may record more Friday, I think. So just want to put that
state,
out there.
well, because the exhibit contains significant content that is not admissible even in a preliminary hearing. So I'm going to stop now. But I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit, and the Archuleta rule would be extended to this exhibit, including that it's not
This
going to be
judge is
broadcast,
patient. I don't know. I wouldn't be
then
so patient with
I think
this.
that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before I go to Ms. Hunt. So going to your first point in regards to this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either
Sure.
side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant.
Yeah.
We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts
Bro.
line by line, word by word. We're prepared to do that. But I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
Oh, no,
I
it's
just
fine.
want to categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's
Okay.
a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here,
Sure.
because there are two exhibits that I'm very confident are coming. There are portions which are not relevant.
The
There are
guy who
portions
wasted our
which,
time promising that you know, his whole DNA questioning was going to be relevant. That turned out not to be relevant and angered the judge pretty well yesterday, is now trying to say that certain things are not relevant. Like, I think he's lost his credibility on what is relevant and what is not. And I'm not trying to be mean to this guy specifically or pick on him because he's the defense or anything like that. But after watching him completely waste our time yesterday, it's definitely, it wouldn't matter. If this guy was on the prosecution, I'd still be upset. He just absolutely wasted time. And now he's going to cry about relevancy. Like, it's just pure hypocrisy.
I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide.
A lot of attorneys do think that they are more intelligent than the judge, because, I mean, to become a judge, you just get elected as an attorney. You know what I mean? So it's not like the judge, most judges out there do not have any type of special knowledge outside of practicing attorneys. You know what I mean? So a lot of attorneys do get cocky. A lot of them are like, I can't believe this judge is ahead of, like, you know, got the position over me type situation. There's a lot of that happens in court. And, you know, attorneys got to generally be careful because this judge he's king of the courtroom. You know what I mean? So if attorneys are not in line, they'll get either put back in line or they'll get kicked out of the court. So, I mean, you got a very touchy balance, because there are attorneys that are way more intelligent than the judge, and then the judge exercises his power, and unfortunately, a good attorney gets kicked out. I've seen that many times too.
Certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Sensitive balance, I guess you could say.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that is probably, for counsel,
well, you knew this evidence was going to be shown today,
where there are
many
time. Or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits, there are no disputes, these exhibits, there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so I will not dictate how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in. But I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state what is in the best interest of your client. I stay clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could have a conversation later if the court wants to. It's up to the court about case management issues. But as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Guess we'll see what happens here.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. it was not accompanied by any objections that he actually had. So we had to compare the transcripts and, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories, but I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing, and then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closure analysis on a topic-by-topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd, on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview, that it's at issue here, is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important, so this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well.
Ooh,
to the extent there's any sort of
good
compromise
choice.
at all,
Storm intro?
the one
Heck
that is
yeah.
presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then
What made you
something
bring up
like
Winter
the
Sun
state
Storm?
has provided, which is we allow the audio to play. If there is some sort of,
choice.
it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure, or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. We take that important. We recognize that its importance. We take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests.
We need
And
Biker
on
Babe's
behalf of
reaction to the
media and
trial.
public, I'd
Yeah,
ask that the court
yeah,
handle
I
this
agree.
dispute
Edie,
that
you
way.
still in here?
Thank you.
We need
Any
that.
further comment by any of the parties? All right. Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument a sidebar, because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
Then we would like to have a very brief closed hearing to lodge another objection about the publication
Don't interrupt
of
the
this,
judge.
of any portion of this exhibit, of certain portions of this exhibit
He
beyond
just said that
Your
it's
Honor's
public.
eyes.
Are you not listening?
That's what I'm saying.
thank you. All right. Right now, what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing.
Heck yeah.
And take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going
We
to
have to
give us
take a
our
break?
15 minutes.
The judge is like,
I
I
want to
have to
review
scoot one
that
out.
so I can be
Court is
brought up to
adjourned.
speed because the transcript, from what I understand, is
He's gonna
just
entertain
a
this.
transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the
appreciate that.
proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are
This
going
lady
to
had
be
the
on the
same
record
sugar-free
and-
Red Bull
and-
yesterday.
and broadcast.
So the court is not making a ruling right now. We're just going to take a break, and then we're going to come back on the record. But on the break, I'm trying to maximize the time, and that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed, so on the next step, when I make my ruling, the court is ready to go.
Okay,
And
fair enough.
maximizing the time, because we also want to put up
Fair
a
enough.
monitor, so there's like 3 things we can accomplish in the space of 15
Fair
minutes.
enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer. Just I want to make sure everything is in place. Let's come back at 3 o'clock, and we'll proceed from there. Court is in a brief recess.
All right.
There we go. Candace Owens is going to have a problem with this court. She's going to start calling it the judiciary, I bet. What do you want to bet? There was a funny, what was a funny thing that I heard? There was some funny Jew joke that I really, I can't remember it. I like made a mental note about it earlier. Whatever. Maybe I'll think later. Bummer. All right. Well, here we are on break. We were fully caught up too. So that's good. That didn't take too long. Now, we had a request, but my battery dying in this thing. I'm probably going to have to run downstairs and grab some new batteries, but I'll try to unplug it, plug it back in. We'll see how long I get of battery life, because we got... How's that sound? Is that pretty good? Yeah. That's some good funky Dimebag Darrell right there. I'll try. Just start smacking it for no reason. My guitar turns invisible at times, so, you know, sometimes it's real, sometimes it's not. Just happens, you know. Wouldn't that freak some people out if they thought that was actually what was happening? Oh, it died. That's what sucks about having any type of active pickups. I only have one guitar that's not active, and it is tuned to... Well, it's in a bad tuning. It's not a bad tuning, but it's the only tuning, because I really need to get off my rear. Learn how to play this song, and then I really need to... learn the song I promised Justin I would learn. It is a weird tuning. Oh, shoot, did I already forget how to play this? Yep, I already forgot how to play Wax Wings. Oh, shoot. Watching Jay Witt as well? Here, let me help you out here. Yeah, just annoy the crap out of you guys. I'm not gonna do that. That'd be funny though. Take that, Jay Witt. Just ruin only one viewer's experience. I guess you could say that. I'll ruin one viewer's experience by just making a lot of noise during Jay Witt streaming. The rest of his like hundreds of viewers won't hear it, but one guy will. Yeah, that'd be so stupid. Why would I even do that? All right, all right, here's my battery pack down here. I got every guitar that takes batteries should have this. Instead of having to take a screwdriver to it, you know, check it out. ta-da, I can just open it. It's like, wow, what a crazy concept. You know what I mean? Every other guitar I have, like this. Oh, wait, no, never mind. This guitar, too, also has it. How hard is that? Unbelievable, right? Which, make every guitar 9-volt. Don't put double A's in it. So ridiculous. But this guitar... Oh, look at this! You gotta take this off with a screwdriver to get to the battery. Well, how is that convenient? Like, of all the things, like, this is Brian Head's, like, signature guitar from Korn. He has an Evertune on it. He's got Fishman Fluence, which Fishman Fluence actually offers a USB port with a rechargeable battery that lasts, like, 10 times longer than a 9-volt battery. Didn't come with that for some reason. And no door. Why? 99% of guitars do not come with a door. They come like this. And I'm just like, what? How hard would it be to just stick the door thing on there so I don't have to mess around with it, you know? But anyway, the neck on this guitar is so much better because it's flatter on the back. Back here. It's not, it's like an elongated C shape, which, oh, I really wish that it was flat. Because that my thumb would feel so much better on the back of it. I don't play like this, like a lot of guitarists do. I play with my thumb on the back of it. And it being rounded makes my thumb cramp a little more. So, wonder if Dime knew what? Because Dime had Dime has a door on his, and Dime also has a triangular neck. So it comes out to a point. So it's flat right here and flat right here, which is infinitely better than a C-shaped neck, in my opinion. Do I know any Megadeth? Ooh. Well, I can learn some Megadeth. I need to learn the newest Megadeth because the guitarist in Megadeth right now is Timu from Winter Sun. So, yeah, it's awesome. Like, the best guitar, one of the best guitarists in the world is on the Megadeth's final album. What a legendary way to go out for Megadeth, to have literally one of the greatest guitarists, which was a total accident. Kiko Loureiro had some family emergencies and had to go back to Brazil. Kiko Loureiro is in Angra, I think. Angra? I want to make sure I get that right, because it's not the Kiko. Oh. Loureiro. Is he in Angra? And so Kiko Loureiro, who's good friends with Timu, was like, hey, you should get Timu in the band. And he did. And I'm sorry, but there's no guitarist that comes close to the solos that, like, if you listen to the solos that are performed on the newest Megadeth album, better than Marty Friedman, and I love Marty Friedman. I'm a massive Marty Friedman fan. But he is better. I'm going to say it right now. People are going to get mad at that. I don't care. I've been a Timu fan for a long time. Okay, what bands is he in? Kiko Loureiro. Yes, he is in Angra. Okay, cool. Oh, wow, he was with Tara. Tara, the original vocalist of, she has her solo albums. You should check those out if you like Nightwish. She was the original vocalist of Nightwish, and then she went on her own and just has Tara, which is Tarja. Check them out, and yeah. Oh, I didn't know Kiko was on their Dystopia album. That was his first album? I thought it was just Warheads on Foreheads and The Sick and the Dying. The Sick, the Dying, and the Dead. Crazy. So he's been on 2.5 albums, technically. Oh, yeah, Winter Sun Storm intro is beautiful. Every song Winter Sun does is beautiful, though. Winter Sun has been my band since I was 14 years old. That has just, ever since I heard them, nothing comes close. I know a Winter Sun solo, so I need to practice it up again. Did you see the Military playing at the Mount Rushmore? The guitar player was awesome. I need to check it out. I actually did miss that. The solos in Dystopia are really good. Oh, yeah. Kiko Loureiro is an insane guitarist. I love Angra. Angra, I found them when I was in high school. Mainly because I listened to a lot of Rhapsody of Fire back then. And if y'all don't know Rhapsody of Fire, hey, Jay Witt. Hey, good to see you, man. Thank you for coming over here. What about the Jay Witt band? Heck yeah, we should start a J-Whip band. That'd be fun. Do a little Kill Tony thing or something, you know? Have a background band to your commentary. Mark Tremonti fan? It's hard to not be a Mark Tremonti fan. Mark Tremonti has one of the sickest amplifiers out there through PRS, the MT. I want to get me an MT-15. I want to get me an MT-15 to my favorite amp back there, which is my Orange Dark Terror. There we go. Orange Dark Terror. I could probably play through that for you guys if you want me to. The orange. I could just set it up with that pedal there on the ground. But my hand won't work. There we go. Right there. I am so bad at mirrored cameras. That pedal, I run a cable through that, and I run it directly into my Axifex here, and boom, you can hear everything I play through that pedal board, through that amplifier, or any amp, really. I can run it through any amp I want. The Ignator is having power tube issues, so there's that. But I can run it through my Hughes and Kettner Warp X or my Dark Terror, which the Dark Terror is just sick. It's absolutely sick. But, you know, running direct through the patches on the Axifex, obviously, sounds great. Angie, did I see your question? Hold on. Can we switch over to either channel or Jeremy's and watch it, then go back to the hearing? Wait, what do you mean? You want me to switch to Jeremy's channel? With Jeremy who? Jeremy Hambley? You want me to watch Jeremy Hambley's channel? Like, I'm confused. Jeremy Boring's channel? Jeremy Hambley? Who is it? Oh, did you comment about the Dimebag step brush? I may have missed that. Oh, yeah. I got mine at Spirit Halloween too, Dent. Good eye. Yeah, I got that from Spirit Halloween. My guitar normally hangs in front of it. I don't have any of my guitars on my wall right now. They're all next to me. See, my hands are empty up there. Oh, my my hands are empty. There we are. Silly. Oh, man. Anyway, should do, let's see. Don't support Ham Planet. Gary's interview. Oh, Gary's interview. Yeah, you guys should definitely check that. I could pull it up, but I don't want to take away any views from Gary. If you guys want to see him, let me pull up his channel though here.
That's admitting guilt. No.
Wait a minute. Oh, this is Valhalla. Why is he popping up? Am I subscribed to him? I am. I don't want to be subscribed to him, to be honest. He's not a fan. I'm really not that big of a fan. I don't mind him, but, you know, let's see. Where is... Here. Popping up. So weird. All right, Jin's on. Cool. Jared's here. In SK. Wait, where's he? I thought... So he's interviewing who? Gary's interview with... Did he already interview Jeremy Boring? Oh. Oh, here I am. Haha. Wait, when's he interviewing Jeremy Boring? I don't know. Is he... Can anyone hear Artie? Oh, am I, sorry, am I quiet? Hey, we could definitely team up next week, man. Heck yeah, Jay. Thank you for that 5, by the way, man. Appreciate that. Yeah, we can absolutely have a stream next week. I don't see why not at all. I don't think I'm doing anything. What was I? Oh, yeah, no. My wife has a dumb meeting coming up this week, but nothing next week at all. Oh, we should be good. Heck yeah. I'm down, man. Let's see. Should play Rockbox Run, DMC/Van Halen. I didn't know he did a song with DMC. Huh. Let's see. Rockbox Run. I'll have to listen to that song later so I can hear it. I won't be able to play it if I don't know it. I know I obviously know that song, so. Got that blues scale going. And I love this guitar so much. These pickups are great. It's that Zakk Wylde kiss. So good. So good, this 7-string. I want to get an 8-string so freaking bad. I cannot wait until I can do it. Coming back anytime soon. Will probably be a while, huh? All right. Yeah, I don't see his, I not see anything about him interviewing Jeremy Boring. So we'll have to see. Did he get it for sure? Or? Heck yeah. Oh, I'll definitely be happy to get back on with Lady Luck. Let's see. Love my Aussie. Just told Jay Witt you were harassing him. Heck yeah. On this channel, we harass people and make them. Oh, I can't say that. I can't say that next part out loud. I was going to say. Sometimes I let my own words get the better of me. Let's see. These kids still playing outside? Oh, yeah. Cool. They're out there. Silly. All right. Just checking on them. Okay. Nothing else. Cool. Cool. I am definitely turning down the heat in here. Gee, why is it so hot? Holy cow. Okay, anyway. Yeah, I don't see that. Here's the trial here. I'm gonna keep this on screen. So that way people don't think I'm not streaming this if they come in. Also be pulling up go. All right. So I wonder if this court's been cooking for a little bit. Why do I have this up? Oh, I made a thumbnail earlier. Right. Let's see. Nope. Didn't want to pull that up or anything. No. Let's see. Jeez, why do I have things up? What is this too? I'm just gonna close out of everything in case. There we go. I don't want to pull up any PMs, as they call them, because they're private conversations. It's not nice. Not that there's anything in them. I could pull all of them open. Nobody would be shocked by anything. But it's not nice. It's very disrespectful. Who am I looking for? Candace Owens. That's who I'm looking for. Probably pull up some Baron Coleman, too. 2 hours ago. Yeah, why is it every time the hearing goes on, she goes dead quiet? You know what I mean? Like, she is not wanting to interact with this trial at all. Sir Custom? Oh, really? They're on X? Oh, definitely that. Pedal Train. Trying to think of who they are. Doesn't matter. Wow. Just dead quiet. How about Baron Coleman? Let's see. Baron Coleman. Okay. I think he's on board. Oh, is he? Wait. He's on Jeremy Boring's show right now? No way. What? Okay, hold on. I didn't know he had his own separate channel. Why does he look different every single time I see him? Every single time I see Jeremy Boring, it's like he shapeshifted into somebody different. I'm not even kidding. He always looks different. Let's see. Live. Okay. He's live right now. I get Paramount Tactical on. That's pretty sick. Pretty sick if he does. Let's take a look.
And of course, the whole thing is a lie in its own terms because a preliminary hearing isn't actually a show or a trial. It's
Dude,
a
what
procedure to
what an
decide one thing,
unbelievably
whether the
cool
case is strong
American,
enough
like,
to actually go to
Chesterfield
trial.
couch.
Candace knows that.
I want a Chesterfield couch badly. That's just sick. This is like the ultimate couch to play guitar on too, because there's no like high back to it, so you can lean back, have your arm propped up and stuff, and still play. Way to go, Paramount Tactical. Wait, what? Where's he at?
Of course, she's betting
what?
String.
Wait a minute. Oh, he just started. Oh, okay, and Gary's going to be coming on here?
Who compromised to see and who's picked up Charlie's sword to go to war with those demons on his behalf. So, okay, she wants to talk about demons, that's fine. There is something truly demonic about this entire affair, but the demonic force here isn't Erica Kirk, a widow now raising 2 children without their father, and it isn't Charlie's closest friends either, the men and women who stood beside him in life and now stand beside his family in the wake of his
He's
death.
not in here yet.
And of course, it's
On
not the
chat,
organization that Charlie bled to build or the mission that he poured his life into. That's mission's now straining, by the way. Trying to carry on the work of Charlie Kirk without Charlie Kirk is no small thing. It also
So
isn't
Gary's
Israel,
gonna be
which
on
has
this?
absolutely nothing to do with Charlie's death, and it isn't our own federal government, which also has nothing to do with it. It's not the Egyptians or the French or whoever else is going to be named on a list that seems to grow every day, an endless roster of people and nations and institutions that Candace has slandered one after another after another. No, the demons here are in the man who pulled the trigger, and the demons are in Candace Owens. The name Satan means accuser, as in the one who stands and points at the innocent and says guilty. That's exactly Candace Owens.
Okay, we'll mute him for now, just so I don't get a copyright strike, just in case. But, yeah. Hey. Oh, there. Wait, what's this Summer Melton? Why do they have Paramount Tactical's, logo here? Who is that? Who are you, you fraud? Summer Melton? Probably just a fan. They probably are subscribed to me, too. I don't know. That'd be funny. Ooh. Gary's the man. Alrighty. Boy, they are going to take a while to come back, huh? Oh, Summer's Gary's wife. Oh, well. I stand corrected. At least it's not a Candace fan. Hey, Angel. Awesome that Summer's so much of a part of the channel for Gary. That's pretty awesome. Something like that. Whatever, I messed up. Distracted by the jacket. Yeah. Yeah, the jackets. Oh, man. You would never, ever, ever catch me wearing Gucci anything except maybe a Gucci tie. Maybe. Depends on what it is. I have a Gucci tie knockoff that was like $20. Looks pretty cool. It's got a tiger on it. Thought it was pretty sick. I used to wear when I was selling furniture back in the day. Which is why I know about these couches and stuff, because I sold furniture for like 6 months. Yeah. Play the Star Spangled Banner. Is it? So it's just straight up and down. It's him. That's not right. Something like that. I don't think anything's out of tune on this guitar with the Everton. Let me check. Oh, I mean, they're all in tune with each other, but only if, weird. Something like that. Love my Aussie. You, Jason, ID, Gary, and LLC are the best. Thank you so much. All of them are great. Every one of them. Just amazing, amazing people. Who's this guy?
External Affairs at the Edmund Burke Foundation, and Gary Melton, aka Paramount
Hey,
Tactical,
there we go.
who served 4 combat tours as a U.S. Army Special Forces weapons sergeant
this all
and
pre-recorded?
sniper team leader, and has spent 9 months going claim by claim by claim through Candace's allegations with actual sourced
I'm gonna
evidence.
expose
A
Gary
thankless
here.
job, but we're glad that you're doing it. Fellas, thank you for being here.
Expose him.
Thank you.
Thanks for having us.
Mark, it's just another
Tell us
random
what's happening
fact
in
taken
Provo.
out of context
I
by
think this
Candace.
is really
then-
interesting. It's different than the legal system in most states. Most people are not familiar with the process.
Is this
like
all
this.
live
So
right now, or
This
is
is a
this
preliminary
pre-recorded?
hearing. We don't see.
Oh, is
this
this
in
a
trials
British
in most
flag?
states.
I instantly
And
hate
what
this couch
people
a
are
lot more
thinking
now.
of is a full-blown trial where you have to prove something beyond a reasonable doubt. This is not that. In
I
a
thought that was an
preliminary
American
hearing, all
flag
they're trying
stripe
to do is
going just
demonstrate
across it.
probable cause. In other words.
Are you kidding me? He has a British flag chair? Ah! That sucks. Anyway, let me, Okay, it's on. Okay, that's where the Star Spangled Banner comes from. So okay. Da 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 da. What note am I missing? No, it's Sorry guys, when I'm doing everything off my on my head here, it takes a little while longer. I'm not super fast, but I'll get it. Oh, it goes down. Okay, so all in there. Okay, I gotta remember that. I keep wanting to go right back to this mode, and I don't know why. That's driving me nuts. Go back to the root there. Da, dun, dun. So, or I can go. Okay, gotcha. I keep wanting to overshoot it to that major scale. So that'd be. Uh, Gotta remember it's these here. All right, that's just kind of how I do it sometimes. You know what I mean? Every now and then I just you got to play it over and over again, then you get the memorization. So. Okay, flip it up to the neck pickup. What the? Really? I've never had the neck pickup go out on me on this stupid switch. It wants to. There we go. I don't know why this switch does this. I really don't. Yeah, okay, here we go. Something like that. Anyway, I'll get it down. I'll get it down here pretty cool. Anyway. The squeaky count is killing you. Maybe I should take it down a little lower. I don't know. I'll figure it out later. It's not too difficult. I just need to, I don't know. I feel like I'm kind of butchering that up a little too much. Anyway, we'll figure it out. We'll get it all figured out. Just got here, starting at the beginning. Heck yeah, Annalie. I appreciate you being here. Boost Nut, worse than Hambly. What, does Hambly play guitar at all? On stream? I don't know, does he? That'd be cool if he brought out a guitar every now and then. Hey, no problem at all. I ought to do my own rendition of the It's all in that scale, so I should be able to get it pretty well memorized. That's how, like, most people think guitarists just pick it up and then they just play. No. Like, sometimes in certain situations, but no. Not how it works. Never how it works. You gotta get your memorization down, and everything's in a different box and a different scale on this thing, and it just takes a few. Like a good guitarist will learn how to play a song like within an hour, but anything about like so many people expect a guitarist to just pick it up, play something they have never really practiced before, and just get it down instantly. That's not how it works. All guitarists like struggle to, do it. We perfect things behind the scenes, and then we play it for you when it's already perfected, That's like whenever the court was going on, the guy's like, hey, can you do Unbroken? I've never played Unbroken before. I love the song. I've never played it before. Took me like 10 minutes to really figure it out, though. Or whatever, Or whatever, Need the Herman Lee sound enhancement pedal? Yeah, right. Herman Lee's great. I like that guy. He's very, very funny. You ever watch his live streams? You should see him whenever they did the effing a duck song with because they were making fun of Ailstorm. And then the vocalist of Ailstorm called him out in the comments. And then they proceeded to have him finish writing the song. It was one of the funniest streams I've ever seen. Of course, in reality, the Ailstorm guys are really, really, really good friends with Dragon Force and all that. And it's just funny. Sam Topman, Herman Lee, and who's the vocalist of Ailstorm? Oh my gosh, what is his name? I know the guitarist has one of the greatest guitar tones of all time. Lasse Lambert is the guitarist. Oh, why can't I think of the guy's name? It's gonna drive me nuts. You should do Guess the Song. Hey, that would be fun. Heck yeah. I should. Like, me guess the song or have you guys guess the song? Because I'm pretty sure any of the stuff I'd play, very few people are going to know the songs. I know such weird songs. That's a difficult pattern to get that. Those quadruplets. Ugh. Very, very difficult. Maybe we should be watching this right now. Maybe we should actually be watching all this at the moment. But then again, I don't want to take away from their, like, premiere and all that stuff. I wonder if this is pre-recorded, though, right? Man, what a great setup. What a really, really nice setup for a podcast. Ah, look at that person walking. Get him! Attack that man! I don't know. There's no reason to attack him, but they're just outside. Let's see. Baron Coleman, anything from you? Yeah, they just go dead silent whenever there's anything breaking in the case, huh? They could be talking about all this stuff right now, and they won't. The show trial. They keep calling it a show trial. It's such laughable garbage. People are just despicable. Despicable people. Candace, have you updated anything? Are you going to stay quiet today? Yeah, she is. What a loser. Absolute loser. They're doing the same thing that they did during the Discord messages, where they just pretend like it never existed, so therefore they could just poison the well. Oh, nice. I have gained a white stripe. Say hello. I'm losing my mind now. I'm bored. I'm bored waiting on this trial to come back. And there we go. I'm going to have to shut the window because that is just pure sunlight. Look at that. Oh, there we go. How do I make it visible? Ah. Okay. That is pure sunlight right there. Just a good streak of it. It just looks white. Let's see. Love Herman Lee and Dragon Force. Dragon Force is great. They're fantastic. Whenever they lost their vocalist, It was right around the same time Leonson, or whatever his name is, Strapoli, whatever their Italian names are. They quit, what's it called? Rhapsody of Fire, which, for those who don't know, Christopher Lee was very involved with the band Rhapsody of Fire. Y'all know who Christopher Lee is. He's Saruman from Lord of the Rings, or, Count Dooku from Star Wars. He's the original Count Dracula. He was the Sherlock Holmes original TV series. And billions of other people that he's played. I mean, he's the old man in Corpse Bride. He's the preacher. Where else is he? He's the Jabberwocky in Alice in Wonderland. There's so many famous roles that he has played. It's crazy. Oh, yeah. He did 3 metal albums. He did 2 of Charlemagne and 1 of his own solo albums. No. That's not true. He did 2 Charlemagne albums, and I think he did 3 Christopher Lee solo albums. So he's got 5 albums out there, I think, by himself and his own band. And then, of course, he's got all the albums where he narrated on Rhapsody of Fire. Yeah, the trial's in recess right now. They'll be coming back. They should be back very, very soon. They should be back very soon. Play some of that. Am I in the right key there? No. No, I'm off. I'm off. What? No. That's what it is. Okay. If you want some Dragon Force here. I lost my tempo. No, that's not right either. What is the next part? What is the song 2 I'm playing? I don't even know. You'll probably know. You're a Dragon Force fan. What song is that? Is that... No, that's not Operation Ground and Pound. That's done. Da-da-da-da-da. No, that's not right either. What song is that? Dun, 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 dun. Something like that. What song is that? It's driving me crazy. Oh, man. One of these days, this case will get right back on it. I'm not paused, am I? Okay, good. Just want to make sure. Watch me have been paused this whole time and trial's been going on. Wouldn't that be crazy? Oh, man. Let's see. Oh, anytime. Just trying to entertain between these breaks. Where's the trial? They're still going. Yep, they are definitely. Lizzie Hale. Is Lizzie Hale part of Hailstorm? Is that her? Is that who you're talking about? Yeah, he served in World War II. He got bombed in South Africa. And then he was one of a few survivors. He was a fighter pilot, I believe, and ended Nazis. Like, he actually did that. let's see, what was his full role in World War II? I think he was he was part of the Royal Air Force, British intelligence from 1939 to 1946. He was fluent in several languages. I think he had like 13 languages he'd mastered. He could speak a total of 19, but he was fluent in 13 languages. He was with the Special Operations Executive, the Special Air Services, and eventually retired as a flight lieutenant. Yeah. Did he survived a Nazi bombing, right? Yes. He survived multiple bombing incidents in World War II. I thought it was just one. Oh my gosh. While serving as an intelligence officer in the Royal Air Force attached to the Special Operations Executive, stationed in North Africa. Oh, it's North Africa, not South Africa. Okay. Stationed in North Africa and later southern Italy. He narrowly survived enemy bombing raids on his airfields, malaria, and on an aircraft crash near the front lines. Like, this dude, like, if anybody wants to talk about, like, 007, this dude was 007. Ironically, he played Goldfinger in 007, so he played the bad guy. I think it was Goldfinger, right? Who did Christopher Lee play in 7? He played the infamous assassin Francisco Scaramanga. It was the man with the golden gun that he played, not Goldfinger. Right. He was the man with the golden gun. So, yeah, this dude is insane. Christopher Lee credits. Let's see his filmography. Are you guys ready for some insanity right here while we wait for this trial to come back? 1948, none of these we'll probably know. I don't know any of his movies from 48 at all. Oh, except for Hamlet. But does that count? Like, that's a play. He was the spear carrier. Uncredited, too. Okay, so that was pretty much nothing. Let's see. Let's get to something that I definitely know. Let's see. I don't know any of these movies. Crossroads? Like the same oh, that's a short film. Never mind. The lady. Or that lady. Okay. Dark Avenger. Let's see. Storm Over the Nile. I don't know really much of these. He played Alexander the Great. Played in Alexander the Great as Nectinibus, but he was just the voice. Let's see. The Curse of Frankenstein. He was, I believe, Frankenstein, I guess? The creature? If that's someone else, I don't know. He was in Tale of Two Cities. Of course, he was Dracula. The original Count Dracula. The good one. Battle of V1. Of the V1, I don't know what that is. Quarter's Blood. Let's see. The Man Who Could Cheat Death. I don't know that one. Oh, yeah, that's right. He was in The Mummy. He was in the original Mummy. He was the Mummy himself. He loved playing the bad guys. Very funny, you know. I'm guessing Uncle Was a Vampire is a parody. Looks like a parody to me, seeing that Dracula is this, whatever the heck that is. Too Hot to Handle, Two Faces of Dr. Jekyll. Okay. City of the Dead. I mean, this dude is in... Let's get to famous films, because you guys will... Let's get to the famous films for sure. He was in Rasputin. That's... let's see. Scream and Scream Again. Count Dracula, of course. Julius Caesar was in that movie one more time. Scars of Dracula is the... Oh, he's in The Three Musketeers. He was Rochford. That's cool. The Wicker Man, of course. He was Lord Summerisle. That's awesome. The Four Musketeers. He still plays the same guy, of course. I mean, then he's in The Man with the Golden Gun. Let's see. Oh, he's in the Captain America 2 movie? That's an old movie. That's a very silly movie. I like how they have his, like, fake ears in that movie. That's very funny. Let's see here. Oh, he was in The Last Unicorn. I forgot about that. That's like an old, like, cartoon movie. He was King Haggard. That is crazy, the stuff that he landed in. Let's see. We're in the 80s. His movies really popped in the 90s up, I think. He was in Gremlins 2. Was he in the first Gremlins? Did I miss that? Gremlins was 84, though, right? Weird. I guess not. Let's see. Oh, yeah, 1990. Oh, yeah, Gremlins 2. Was it Gremlins 87? I can't remember when the Gremlins came out. Let's see. Police Academy. Mission to Moscow. Let's see. Hail the Mummy. Sleepy Hollow. Lord of the Rings, he's Saruman, of course. Star Wars, he's Count Dooku. Lord of the Rings, Saruman. This is where things really pop off. Charlie and the Chocolate Factory, he's Dr. Wilbur Wonka. Corpse Bride, of course. Pastor Galswell. The Golden Compass. Star Wars, Count Dooku. Alice in Wonderland, he's the Jabberwocky. Season of the Witch. Dark Shadows. Let's see. Night Train to Lisbon. He's mainly in like television. Mainly that's and television movies or animation. Let's see. Haven't seen The Last Unicorn. It's a classic. It's an old cult classic. It's not super popular, to be honest, but a lot of people should probably know it. Let's see. Let's get to TV shows everyone will know. He's in so many like voice acting roles. It's crazy. He's in Treasure Island. Oh, this is a different Treasure Island. No, it's not. No, it's the 90s film. Yeah. Heck yeah. Blind Pew. I'll have to rewatch that. I haven't seen that in a long, long time. Young Indiana Jones Chronicles. Let's see. He's in the Odyssey, of course. We knew this. Like, you can hear him in the Odyssey. Tiresias, I think. Or Tiresias, I think? Tiresias. That's how you say that, I think. Man, I am so upset with the new Odyssey movie. I am so upset with it. It's unbelievable that they would just ruin it. I mean, it's not unbelievable, we know, but come on. Let's see. Theater, audiobooks, awards and nominations. That's not all the credits. I mean, he's in Kingdom Hearts. We all know that, but that's not everything he's done. Where's television? That's not even close to everything he's done. Huh, odd. That's really, really strange. I wonder if they just don't have a lot of his cameos. Like, his cameos are ridiculous. But anyway, super crazy, crazy skilled, talented actor. He passed away in 2015. Dang. That feels like forever ago. I can't believe he's been gone for 11 years. Wild. It feels like he just passed. Dude, how long have we been in? We have been in recess now for 52 minutes, guys. We have been in recess for 52 minutes. This is way over 20 minutes. What is going on? I hope that judge is giving a tongue lashing to these people or something. I don't know. I hope he's getting on to some people. For older kids, it's a book. Amazing. Oh, really? Yeah. Last Unicorn. I haven't seen The Last Unicorn since I was like... I don't even know how old. I know, I don't know how old I was. My daycare showed it to us. And then I know Danny from from NSP. He's on Game Grumps. He was a big fan of that movie, and he was helping push that movie out whenever it was getting re-released. Yeah. I think they would learn. Man, that attorney is bickering. Oh, does he really look like Brian Inton? I just subscribed to that dude's channel, too. Man, I wonder what is taking so long for this, to get, why is this taking so long to get resolved? Hmm. Love that riff. It's a good little diddly. They were arguing over a video being submitted into the court, and they said it needed to be redacted more. And I don't know if it does actually need to be redacted more or not. I don't think it does. I think it's should be fine. Mainly, I don't think it does because they didn't get off their rear end and request for it to be redacted in the court until they were actually in court. So, I don't know. They should have raised this issue a while ago. I think they missed the... I don't know. I would have thought that they missed the deadline. But apparently this judge does not think so. Because if the judge thought so, I feel like this 20 minutes would not have been 54 minutes or whatever. How long have we been here? 5:56. Yep, 56 minutes ago. Whew. All right. Well, you know what, guys?
Of evidence and calculate.
All right.
Began laying out the evidence against Tyler Robinson, the man accused of murdering Charlie Kirk.
We'll just
the
watch some of
forensics,
this.
the video, the medical examiner's findings. Charlie's parents are sitting in that room. His widow is sitting a few feet from the man accused of killing her husband, listening to the worst day of her life read back to her over and over under oath. Candace Owens looked at that and called it a show trial, telling her audience to expect nothing but, quote, Erica's tears and an orbit of her payrolled influencers trying to convince you that the unvetted evidence is overwhelming and undeniable. She said the, quote, real trial would come later. One of the more extraordinary things a free people does, sit down under rules, under oath, in front of the cameras for the whole world to see and establish with facts and evidence what really happened to a man executed in broad daylight in front of thousands of witnesses, has been dismissed by Candace as theater because the truth threatens to shatter her empire of lies. And, of course, the whole thing is a lie in
Court
its
is
own
back
terms
in
because
session.
a preliminary hearing isn't actually a show.
Well,
Noting
never
the
mind.
presence of counsel and all parties. I appreciate your patience. Sometimes it takes time to save
I didn't want to play it
time, and
live,
so that
though,
was
because,
the intent of this court
I think that would be rude to do to
in
him.
addressing what is before this court as it relates to State's Exhibit 16. Counsel, this time I've taken time to look at the video anew, also reviewing what Mr. Novak submitted, the redactions requested,
Alrighty.
and reviewing all parts of it in great detail.
Oh, hey,
All
they
right.
got his
I
nameplate
want to
fixed.
address
I was going to point this out earlier.
objections before
He had no
me.
nameplate. But now he's got a
And
nameplate.
starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride. And the court agrees, it is hearsay. At the same time,
Judge Jr.
I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16, And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to like scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding.
Okay.
But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again. To be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript, as it relates to State Exhibit 16, may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript,
believe
and
me,
again,
you have not
State's
missed,
Exhibit
much front, but
16,
there-
that may not be admissible at trial.
Not
and
much
whose
at all
relevance
yet.
I have not yet
They've
determined.
been arguing for
In
the
the
last
abundance of
50
caution and
or
to
for the
protect the
last
jury
hour,
pool,
they've
the
been in
potential
like
jury
remission
pool,
here.
from
So-
hearing potentially inadmissible evidence,
Yeah.
I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video. So both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point.
Boy, that paper was
It's an
loud.
approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning.
I'll tell you what you did miss, though. You did miss
Until at page 19, 3255.
You did miss the arrest times. Completely destroyed Candace Owens and Baron Coleman's claim that he got arrested like earlier than what he actually did. And I think that's it, actually. Never mind. I think
That
that's all.
portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you are ordering not to be published? I've got 3255 to 3548.
Right. Those are the two timestamps
Okay.
for that. And I hope that's helpful as both parties are trying to review on the transcript and State's Exhibit 16.
Okay.
That's from 3255 to 3548.
Right.
Okay, thank you.
Is not publishable in the courtroom or on to be broadcast. Finally,
Bummer.
I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because I
Sure.
do think a closed hearing is appropriate.
Oh my God, this guy's going to argue.
There are,
They got it resolved, right?
okay, setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay? Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay? I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially on in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a
So I could explain that to you, Dempsey. You do not understand why Tyler Robinson is not implicated as an accessory in this crime. He may be. There's still time for that. Well, essentially what they did was they said, hey, we want to get to the truth of this. We're going to not arrest you if you tell us what Tyler Robinson did. A district attorney can come back later on and be like, hey, actually, he was more involved than we realize. He needs to be arrested and charged. But essentially, they're like, if you turn yourself in, if you tell us everything that happened and what Tyler Robinson did, we may let you go or give you very minimal time. We will not throw the books at you. And then he was like, okay, cool, I'll come clean. So essentially, he threw Tyler Robinson under the bus completely for what happened. Long story short, at the price of you might not get arrested. At least you won't get arrested at this point in time. Maybe charges come back up later on. If they find out that Lance Twiggs completely and totally put Tyler Robinson up to this and was very much way more involved, their hands will be tied and they'll be like, hey, we don't really have a choice. You know, but if it turns out he was very minimally involved and is able to give all the information over to show that Tyler Robinson was the main person behind all of this and maybe a few other people, then they may just go ahead and waive the charges. It just depends on how involved he is. So we'll put it that way. It's kind of a toss-up right now.
decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's RIDEAU, this court constructed a rule that the televising of a defendant in the act of confessing to a crime
I
was
cannot believe we are
inherently
still
invalid
arguing this
under
after
the
they
due
took an
process
hour break
clause
to argue
of the
this.
14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding.
Yes.
And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms
I
of
don't know,
technology.
maybe he shouldn't have
but
confessed.
I'm just going to use what the Supreme Court says because it's the Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial violates Mr. Robinson's due process rights right here and now today. And I know that we said that before in the litigation, but now we're exhibit specific. If I haven't been clear about the argument, I want to make sure I'm clear about it because the court's decision
You had an hour to be clear.
Allow
This
this,
dude
video
sucks.
to
He
be
probably
televised
droned on for an
and
hour.
the other two exhibits to be shown to the camera in the back of the courtroom is exactly what the Supreme Court says violates the 14th Amendment.
You should have said that an hour ago.
So, and I appreciate that clarity, and perhaps, and again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it in the
It is
court?
not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time.
Oh my
It's probably
God.
easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client, and so I want to give it its due time. The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months
Yes.
ago in their entirety.
Yes.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported
They have
in part
more.
the charges that the state has
Okay.
filed.
That's good.
We did not put the entirety of them in. And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells. I want to make sure.
I'm aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court, and I'm confident that the state's counsel would never intend to do that, but that would be the consequence of further televising what the state refers to as, previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party.
Are you guys have a Mr. Novak at your?
We have not filed
your kid's
anything
school? That's funny.
in this case that publicizes the text messages, the Discord chat, the note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that, yes, we want this note to be presented into evidence, and the court knows what this note is because the court's now watched the video. That's another piece of the same problem. So this is all simplified by the court being extra cautious about Mr. Robinson's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right. I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this, and I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and pause or get the actual exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything audio and visually displayed, but the state's position is we just want the audio played.
Right, but what's it?
He froze.
So I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
Oh, she swapped for a monster.
So help me understand, what's the difference if the audio's played or the video's played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy. I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio. It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twig's video.
Okay.
And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me, but it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
You had an hour to figure this out. What's going on?
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then, in the future, move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with the audio. But hearing the tone, the context, all of that, that's why the state chose to do, we could have done a written 1102 statement from Mr. Twiggs. We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context,
I have a feeling
Mr.
this
Twiggs
court will not
actually
wrap up
talk
before this.
and talk through these exhibits, talk through his experience.
Or will wrap up before this is resolved.
A meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
Here we go.
I learned a long time ago.
Violation again.
That when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations. Because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now, I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963.
Don't drone on about that. Jeez, who cares? Why do they freeze? He's just like frozen now.
Citation to
there you go.
State standards for what is or is not a public document are not the issue. There's a constitutional issue here. And I think that the court has already heard from me at least 3 times about what we think the court should do here. It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether potential jurors were exposed to media replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question.
Groaning. I can't believe we still got this
versus
argument
Louisiana,
going. Hey,
and
could
that's
I
why
borrow
in
like
Estes
6
v.
of you
Texas,
guys real
the
quick?
Supreme Court said,
6 of you
we have a
unsubscribed
rule.
guys?
You can't televise what a prosecutor.
I'm going to mute this real quick because, man, they've been arguing this thing for hours now. If I could borrow 6 of you guys real quick to help get us to 30,000 subscribers. How about that? We are so close, guys. We are so close. Thank y'all so much for being here. Let's see what he's going to say. Not all at once, my lord. Oh. Okay, let's fast forward a bit.
Consideration of the argument, which again, I appreciate the parties articulating. The further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8,
And Mr. Novak is pretty annoying,
Sorry,
I'd
I'm
say.
trying to-
Woo! We need 5 more subscribers, guys. And then we're at 30,000. Crazy. It's going to happen right here on this live stream. I guarantee it.
Sorry, it started on page 7.
Yeah, they
right
filibustered
after- it's
hardcore
at
yesterday.
8. Well, let's start. Starting on page 6.
Subsection T, or section T,
Wow.
subsection 9.
Let me go back here.
Ba-da-da-da-da-da. Need 5 more people to subscribe. Oh, Patrina, thank you so much for the 5 memberships you gifted. That's Haley Hopes.
Starting on
Welcome
page
aboard.
6, after 6
Shenley-
minutes and 56
Shenley.
seconds.
Jukebox, Noble Savage, and Richard Crocker. Thank you all so much. Or thank you so much, Patrina. And welcome aboard, guys. Heck yeah, let's get up there to 30K. 2 more people subscribed. Heck yeah. Holy crap, you guys are insane. Just instantly. Let's do it. Let's see it. We're going to get there. It's going to happen. Who's going to be number 30,000? Could be any one of you guys.
Going to 20 minutes and 27 seconds. For reasons such as 403. Under Rule
And there we
403.
go. 30,000 guys.
And again,
Alexandros,
this
I
is
believe,
simply
is the
for
one who
publication.
actually ended
This
up
is
doing
not
it.
Taking out what the court will
Thank
consider.
you.
The court is considering
We have
the
reached
entirety of
30,000.
State's Exhibit 16. But the court
30,001
is
though.
trying to take a narrow
Hey, we can keep
approach
going.
in
Let's get to 40,000
recognizing
right
and
now.
Balancing transparency
Thank you guys
with
so much.
constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish
Wait, no.
the court's duty as a magistrate under the probable cause determination. All right.
Can you state those times again, Your Honor?
6:56 until right the line before 2027
2027.
or 2027, just so until 2027. Is that?
Boy, they're going to play like,
And then
out of
the
this
pre-
video,
and
they're going to
then
play like
what
5
the
minutes
court
of it.
indicated
Hey, thank you,
previously.
G-Up. The Honorable Artie Trolls.
from
Your unsub didn't work at 30,000? Yeah. Hey, you tried, mister. You got to
3255
30,001 unsubbed, resubbed. That's funny.
until 3548.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 3255 to 3548 and 656 to 2027.
Well, let's make this like,
Those are just not being published, but they have been admitted for your honor's consideration.
Right, so kind of going through my 3-step process. Exhibit 16, it's an
You would know this if
entirety,
you were an
not the
alcoholic.
transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety
There we
for the
go.
court's
Put this in the corner here. That'll be fun.
determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and and captured by the video.
man, thank you guys so much.
Is
guys
the
are amazing.
differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations regards to
Yeah.
relevance and everything that Mr.
Take a little screenshot.
Everything that Mr. Novak noted, I'm taking that in consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to publication.
Yes, thank you.
All right, to the media.
Thank you, Your Honor. I know how much time the court's already dedicated to considering this, and I appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make at the conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there. Something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And, all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job.
Be out of everyone's way.
But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial.
Whatever.
You'll use them if you find that you need to.
Thank you guys so much.
That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties? Mr. Novak, and your mic's muted.
Yes, we just want to say that we totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? With all due respect to the Kirk family, and with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding.
You get a chess clock for this guy? I love that. That's funny.
Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau. My French is bad.
Mine too.
D. Hampton? I could definitely learn some
that constructed
AC/DC.
rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions being put out to the public. Could you cite to Estes that supports?
The portion that the court is looking at is exactly what I would read to the court. It says, we constructed a rule. Now, I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a Supreme Court opinion when there are multiple concurring and dissenting opinions. But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial vis-a-vis that earlier televised analysis. So yes, we could go down what lawyers like to do, we could go down the rabbit hole of what were all the different opinions in Rideau and why is Estes citing to a dissenting justice. But what Estes said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment. The Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr.
I
Justice
forgot I muted myself.
Goldberg,
This guy is
and
like
then there
very
were
condescending,
dissents
isn't he?
by Justices Stewart, Black, Brennan, and White.
See how high we can get this number to go, by the way,
we could
guys.
spend some
Thank y'all for
time
being here. It's amazing. You guys are awesome.
deconstructing that, but it's a 5-4 opinion of the United
5-4.
States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4
I don't know why I didn't do
opinion.
this earlier. All right, let me.
And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So Taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to $20 and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 32:55 until 35:48. Does that comport with what I previously said?
Yes.
All right. And then from 35:48 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line.
Yeah, it is.
One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence, and based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act. But I'm trying to act in the interest of justice in making this balancing act, and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it, or do you wish to go a different route?
I think just to make sure that we are.
I'll get to the
completely
super
in line
chats
with
here
the
in a
court's
second.
ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And
I don't
know this has
disagree.
been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state.
Okay, so I'm going to get to my kind of opinion on this real quick. I agree with the judge. I think it's fair, and we'll get to see the video tomorrow. What I'm irritated with is how the defense was late on this, and the judge didn't really say, hey, tough, you should have brought this up earlier. But anyway, we got a lot to cover just real quick. Haley Hopes for the $10 says, congrats on the 30K. Thank you so much. That's you guys who did that, by the way. You guys are responsible for this 30K. I am just at a loss of words. You all are amazing. Thank you so much. Then she says, thank you for all of the work you put into keeping us informed and entertained. Hey, thank you so much. I'm trying to figure out the best ways to entertain you guys with some of the stuff that I do. I really, really appreciate that a lot. Thank you so much. We have Victoria Green sending a gift membership to Harmony Davis. Thank you so much for that, Victoria. I really appreciate it. And then we have Cece here giving 5 memberships away to DK. We have Heather G. We have Mackenzie Carter Cameron. We have Hello Tom. Adam this. And Mr. Cheese. Yeah, and Mr. Cheese. Thank you guys so much. Thank you so much, CC, and welcome aboard, guys. Thank y'all so much for that. Alrighty. I think I don't know. This judge, he's very patient, which is a good quality. That's a very good quality of him. I'm not knocking him for it. I kind of wish the judge would have been like, look, you were late on this. You did not iterate this. You could have brought this up to the court earlier, to which they did not. But the judge is ruling a fair decision. This is the decision I would expect if they were on time. You know what I mean? He's given a little bit more leeway to the defense when the defense was not prepared when they should have been prepared, in my opinion. But he is given a fair ruling. It's just the kind of ruling that I would have expected if the defense was actually prepared instead of not prepared. So that's kind of my take on this, I guess you could say.
Simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, no.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
Yeah, just a moment.
Of course.
Well, I'm guessing they're probably going to end the courtroom a little early. I don't think they have. This is probably going to wrap up here, if I had to guess. Let's fast forward.
Someone could say.
There we go.
And I know the state's engaged, but if someone could send a copy of that to the court after it's been reviewed by counsel so the court can review it to double check that it comports with what time as well.
That the defense isn't full of crap, yeah. That's,
you.
We get it.
Those edits have been made. We can start tomorrow with that and proceed from there.
Okay.
All right. Any opposition from defense?
He ruled that the video must be redacted at the certain
No, Your Honor,
timestamps, and then they'll play it tomorrow.
I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis.
No more. I would say no
Agent
more.
Davis.
No more.
As to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's
Okay,
not a
fine.
25-page transcript.
Just get rid of them. Whatever. Oh,
I'm
my
not
God.
suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated.
This guy makes me want to put my head through a table.
I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord, and the note. All of that is part of the SD's issue. And I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to
This guy is
the televising
long-winded.
of
Ooh, we got
statements
10.
that the
Use that hand.
prosecution
All
will call
right.
confessions.
Thank you, guys.
So maybe
I'll make
that's
this
something.
my
It was a
head, 'cause
different
I have like a
prong that I was
barrier right here.
addressing.
Good, okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be
By the way, if I do
revisited
that, it looks like
to
I'll go
the
behind.
redactions that's made
For
public.
evidentiary purposes as opposed to for publication purposes.
Right,
Understood.
right.
But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to
Ugh.
maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward, because I want to look at in detail what you're citing to. It's difficult on the fly to jump into Estes and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time, so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank
No
you,
problem.
Mr. Novak. And if you wouldn't mind, obviously, sending a copy to the state as well.
Of course, of course.
Thank you, Steampunk.
All right.
Is the court referring to
Thank you
a
guys so
formal
much.
filing?
No, just if you
A bench
want
memo.
a bench memo, and that all sides can have a take a look at, just to prepare. Again, in light of efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully.
Yeah, Mochi Mom,
as opposed to trying
you
to
missed this guy
hit them at the moment
being
and
as long-winded as
doing a deep
possible.
dive
No,
when
I'll
it's
fill
a
you in.
little bit more difficult. So
Happy to do so.
if you'd like to, I would
can we-
entertain that to the state. If you want to confer and talk to see where you are and want to.
Judge.
All right. All right.
Is this it?
Until 9 o'clock tomorrow morning.
Okay, court's done. Yep, they got rid of it a little early. Wow, did they ever waste time? They wasted more time today because of the short amount of time than I honestly anticipated. They wasted so much time. It's crazy. I'm going to mute this real quick. We'll just kind of see what's going on the outside, I guess. Wow, did they ever waste time? But I'll tell you guys essentially what happened. Okay, this is the entire court can be summarized as to this. Okay, they showed that Tyler Robinson was arrested at the time we thought he was. It was like 4 a.m. on the 12th or something, or not 4 a.m. at the 12th. It was 9 p.m. on the 11th, I think, not 6:30 p.m. where Brian Coleman said that he was arrested. So that's completely, totally debunked. Baron Coleman, he's totally debunked. It doesn't even matter anymore. They showed Tyler Robinson on video in his hat and his red shirt, his maroon shirt. There is no question now at this point in time that was Tyler Robinson on camera in the stairwells. No question. So there's that. Then we also got this video that they've been arguing over for 2 hours now. And that video is going to be shown tomorrow with redactions. So there's about a good 40 minutes, I think, being cut out of this video. It was like from, maybe it's like 27 minutes, actually. I know at least 20 minutes of important information's cut out. And then they have another section that's cut out that's somewhere between 7 and 20 minutes long as well. So it's anywhere between 27 minutes being cut out to 40 minutes being cut out of the video tomorrow that they're going to show in court. Once we get done showing that, I'm sure tomorrow's courtroom is going to be a repeat of arguments that are going to last forever. I wonder if this live stream ends up cutting into next week, or this court. This court may actually not resolve by Friday. It very well may have to go into Monday and Tuesday of next week if they keep up at this pace. Then again, it might not, because all they need is one piece of evidence to show that Tyler Robinson is possibly the person who did this, and then the judge moves forward and says, okay, now we're setting a court date up. So this is a preliminary hearing. I imagine the judge then will, probably this Friday is the most likely date, of course, will then set a date for the pre-trial. And that pre-trial will probably take place in the next 6 months. After that, we'll probably get a date for the actual trial. Or the judge will just go straight into the trial. To which that will be 6 months to a year from now. It could be that as well. I don't know exactly when we're going to see that. We'll find out Friday, but I don't know when it's going to be, the date is going to be locked in. Now, keep this in mind. As the date is locked in, that doesn't mean it's actually officially locked in. The defense could ask for extensions, and then we get an extension on that. I don't know if it'll be set in stone, but we'll have a date to shoot for at least. I imagine as we get closer to that court date, it'll probably get bumped a couple of times. I hope it's not a repeat of the Brian Kohberger trial, where the trial got pushed back for years. Years it got pushed back for. I think it was pushed back for 2 years. How long did Brian Kohberger trial get pushed back for? It was ultimately delayed over 2 months, pushing the start date. No, it was delayed more than that. It was delayed from June 2nd to August 11th. The prolonged scheduling was ordered to accommodate jury selection to allow the trial to conclude by November 7th. However, the trial did not occur because Kohberger pled guilty. Oh, yeah, that's right. It was like 2 years that it kept getting delayed or something like that, and then he pled guilty as soon as the trial was fixing to start. It just undercut all of it. A lot of people were mad about that. Need a mega pint? Heck yeah, going for that Johnny Depp. That's awesome. A mega pint as opposed to a pint, you know. That was a great phrase. That was a great catch by Johnny Depp, too. Great catch. That was pretty funny. A lot of people saying 2028. I actually doubt it. I genuinely doubt it's 2028. And the reason being is because this is a high-profile case. I bet it's expedited. A lot of people are saying 2027, 2028. I am actually going to make the bet, and I could be wrong, of course, but I'm willing to make the bet that it is going to be late 2026, early 2027. And I say that just because of the significance of the case. I bet it gets a little expedited. Of course, that depends, too. There are many different ways they could go about that route. They could end up siding with Erica Kirk and deciding that a speedy trial is going to be the case. But that's rare. Usually they side with the defense because it's the defense. The defense gets all of the benefit of the doubt. So more than likely, they're not going to go for a speedy trial. That being said, they could still expedite it. They could still expedite it quite a bit, you know? Yeah, well, Brian Kohberger may have waived a speedy trial. However, it's not always up to the defense. The victims of a case have a say, and a judge can side with them, and they can decide a speedy trial is what's necessary. It's just very, very rare that they side with the prosecution on a speedy trial. But the prosecution does have the right to request a speedy trial. Both sides get that right, but it's almost always in favor of the defense, and if the defense says no speedy trial, 9 times out of 10, they're going to side with the defense. I agree, it should be a speedy trial. But they don't want to risk a mistrial. They don't want to risk anybody coming out and saying, hey, this was unfair, this shouldn't have been tried this way, and then they get a mistrial out of it upon appeal. That's something that no judge wants to have happen because it's not good on their record. And a judge wants to have a good record more than anything. So, you know, it's totally understandable and it's totally fair if they don't get a speedy trial. So, yeah, 28 is way too long, and Erica Kirk did request a speedy trial, which Candace Owens tried to take out of context and go, oh, they're trying to violate his rights. That's the dumbest thing I've ever heard. Why would she be allowed to request a speedy trial if it violated his rights? It's just so profoundly stupid. Candace Owens should be dragged through the mud for saying something so profoundly stupid. People should pick up on that and be like, whoa, Candace Owens really is an idiot. She really is an idiot and has no idea what she's talking about. So it's just profound, you know. It's profound. But at the end of the day, people are going to fall for Candace Owens. And it sucks. It's because she has such massive reach. She has snowballed so massively into her 6 million subscribers. There's not a lot you can do to take a channel like that down. There's really not. She could screw up so bad. So bad. More than anybody, she could make the worst mistake of her life on her channel live in front of a camera. And she'd probably only lose 1 to 2 million subscribers. She'd go back down to 4 million, which, guess what, would still be more than enough for her to continue, and would still be more than enough for her to make billions of dollars. There's nothing really anybody can do. And it's just because people are stupid. And, you know, that's just life. That's just life. So I'm not interested in trying to take Candace Owens down, to be honest, on that front. Because it would be a waste of time. People are dumb. They're going to remain loyal to her. It would be a waste of time in general to go after her that way. Just would be. Facts, you know what I mean? But, you know, it is what it is. People are going to continue to support her. She could get banned off YouTube. Guess what? She goes to Rumble. And guess what? Millions of subscribers go with her. You know, so there's just... people should get that out of their heads. You know what I mean? It's just the way it's going to be. Forever, Candace Owens will be platformed. So, you know, it's just one of those things that everyone's going to have to accept. So, you know, don't get me wrong, it sucks, but I mean, it is what it is. You know, bad people get platformed. You know, look at people like what is it, Johnny Somalia? You know, it's like that dude is the butthole of the internet. That dude is hated more than he is liked, but he will still have an audience of millions. It's just a fact, you know. And that dude, like, it's crazy how many people hate that guy. He's probably got 20 million people who know of him that hate him. And I think he's got an audience of like 3 or 4 million people. So he's set for life, even though he's in a Korean prison cell right now. It's just hilarious. But, you know, yeah. Did you see Paramount Tactical was on Jeremy B? Oh, yeah. Yeah, we did see that. Right here. This is awesome. Good for Gary. It's still live?
Candace has in all this. I mean, she's created a whole
Heck
new
yeah.
genre of entertainment.
Oh, wait.
Most people, most
There we
reasonable,
go.
logical conservatives that don't like what she's doing, but aren't in the weeds of it, and they won't engage because they can't argue it.
Right.
But when you throw out something like an exploding mic that, again, enough force, enough energy to kill a man, and by the way, their claim, not mine, that it destroyed the microphone itself, but it didn't create a hole in his shirt, didn't even come loose of the magnet.
No video.
Like, no equal and opposite reaction.
Right.
Like Newton's third law still applies here, but you just
Good
want to
man.
suspend that. So, I
Man.
mean, the real answer is people have to get...
Screw debating me, Candace, but debate him. He's better at it than I am, for sure. Oh, man. Gary's just fantastic. Fantastic. Everybody, come over here, Jeremy Boring. I know he's... Wait, 48,000... What? He just started this channel? Holy crap. 48,000 subscribers, that's it? Guys, go subscribe over here. Let's go over here. I'm going to get you guys the link here, right now. So, this is Jeremy Boring's channel. That's crazy that I didn't know he just started this channel. I'm going to pin it. Hold on, don't click the pin thing yet. Replace pin. There we go. All right, there we go. Now you guys can go over there for sure. Raid this. It's still live, right? Where we at? There we are, live chat. Go on in here. Man. Oh, man. Absolutely amazing show. So, guys, come in here, come into chat here. Let's go on over there. We'll get live tomorrow over this whole thing, over the court case. Hopefully, it does not drag on stupidly. We'll see what happens. Stepped away a minute. Do we have an idea what the contents of the video will be tomorrow? I know Grits knows. I don't know. I'm in the dark about it. I think it's a little more fun to be in the dark about it, actually. I'm excited to see what evidence comes out. So, you know, we'll all go through it together. So, there is that. Gary is killing it on Jeremy Boring's show. Absolutely killing it. Good on him. This is incredible. I am just blown away. Good job, Gary. Congratulations. Just wonderful, wonderful, wonderful person right here. Absolutely glad to see him killing it. Just, yeah, it's great. Absolutely great. But yeah, guys, go subscribe over there. Yeah, Paramount, not so tactical. I think it gets clever. Yeah, it's really, really dumb. Oh, man. Candace is an idiot. Like, oh, well. Yeah, his interviews are good. Jeremy Boring, yeah, I mean, Jeremy Boring's aight. He's aight, you know. Matt Walsh, I think, is probably one of the best on the channel. Ben Shapiro has always been really, really good. I've never had really disagreements with Ben Shapiro directly. I think Daily Wire as a whole has been, you know what I mean? No, I'm not the biggest fan. That's just my opinion. I totally understand and respect if you like him. Jordan Peterson has always probably been one of my favorites. I still see Jordan Peterson as separate from Daily Wire, but that's just because I was a big fan of him way beforehand. So there's that. But yeah, that's great stuff. Go there and subscribe, guys. Be here in the chat, be active, and yeah. Oh, Ed Gold, hi, Artie Trolls. I've been meaning to watch your show more often. Always glad when I can catch something on your channel. Oh, that's nice of you. That's very nice of you. Oh, man. So many nice people. Samurai's in here. Samurai's right here. Heck yeah. Alrighty, guys. I'll see you on over there. I'll pop in and out and whatnot. I guess I'm going to go ahead and hop off here. I'm going to help cook some dinner. I am starving. And I'm sure those kids are rowdy as all can be. Thank you all so much for getting me to 30,010 subscribers. Let's try to get that number as up as possible because the higher the number goes, the higher the likes go, the more people that come on in. Let's grow this channel as much as we can. You guys are absolutely amazing. Thank you guys so much for this opportunity and everything you all have done. Before I hop off, of course, I am going to read off all of the super chats that came through and the trolls who have joined. We have Melissa Mares, welcome as a troll. Renee Ferry, Dust Bunnies, welcome as a troll. Thank you so much for both of you. Victoria Greenfield joined as a troll. Thank you so much. And then Renee Ferry also sent a membership to somebody in the chat. Thank you so much for that. Eric Goss for $20. Thank you so much, man. And another $5 from him. Dude, thank you. Jay Witt, he's the man here. Oh, he's so good. His channel is amazing. Everyone should go check out Jay Witt if you have not. He donated a $5. Thank you so much. Love My Aussie for $4. Thank you so much for that. Patrina Rich for gifting 5 memberships. Renee Ferry gifted another membership too. Thank you so much for that, both of you all. Haley Hopes for $10. Thank you so much for that. Victoria Greenfield for sending a membership as well. And Cece Bingham for sending 5 memberships. Thank you so much, guys. You all are absolutely incredible. We'll be on tomorrow. I believe it will be 10 a.m. Central Time, 9 a.m. Mormon time. We're going to call it Mormon time. And, of course, that will be 11 a.m. Eastern Time. And California time would be 8 a.m. So, yeah, all you California guys better wake up early. California, Seattle, Washington, Oregon, all you guys there. Going to be an early morning for you guys. Thank you all so much for being here. Please like, subscribe, and share, guys, and let's get that number up, and I'll see you guys here in tomorrow's live stream and tomorrow's videos. Later.